The webinar will begin shortly. Please remain on the line. The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. My name is Keith Grellner. I'm the chair of the Washington State Board of Health. And today is a special meeting of the State Board of Health. This meeting is being held under the provisions of the Open Public Meetings Act, Chapter 42.30 RCW, and board bylaws and policies. Notice of this meeting was provided in accordance with the Open Public Meetings Act. The agenda and materials for this meeting have been available since 5 p.m. on Tuesday, May 11th on the board's website at www.sboh.wa.gov. Those members having a conflict of interest on any item coming before the board will report that conflict with respect to the particular subject under consideration. In case of challenge by any board member or the board shall decide the status of the challenged member to participate before considering the substance of the matter. Note that for today's meeting, the Secretary of Health, Dr. Shaw, has recused himself from today's matter due to potential conflict of interest. Dr. Bob Lutz remains recused and screened from this matter also. This meeting is being held virtually. The purpose of this special meeting is to review the findings of an independent preliminary investigation that the board requested after receiving complaints under RCW 70.05.120 regarding an alleged failure by the administrative officer for the Spokane Regional Health District to carry out public health law in relation to the termination of the district's local health officer. If the board finds a hearing is warranted after preliminary investigation, a hearing will be conducted pursuant to Chapter 34.05 RCW, the Administrative Procedure Act. Under the APA, the board may determine who will serve as the presiding officer for that hearing. The board will only reach this item on the agenda if it determines that a hearing is warranted. The board will not be taking public comment on this matter today. The public may submit written comments to the board via email at wsboh@sboh.wa.gov. Thank you for your interest in today's meeting. First up on our agenda today, aside from calling the meeting to order, we'll do an introduction of board members. Board members, I'm going to call you by first name, and if you would please give your standard introduction for our audience viewing the meeting, that would be great. First up, we're going to start on the east side of the mountains, and I'll ask Fran to introduce herself, please.
I'm Fran Besserman, and good afternoon, everyone. I represent the public.
Hi, Fran. Thank you.
Hi, Kate.
Next up, we'll go to Vasaskia.
Hello, can you see me? Oh,
we can see you. Hello.
Oh, great. Hi, Keith. Hello, I'm Zaskia Krupfel. I am, I work for, wow, I don't know why I got all confused. I'm Zaskia Krupfel, and I represent the community. I work as a director of equity and social justice.
Thank you. Welcome. Next up, we'll go to Steve. Steve, you appear to be on mute, but it doesn't look like it on your thing. Kelly, can you help Steve?
I'm unmuted now. I unmuted for a second, then it must have muted itself again. My name is Steve Kutz. I'm a member of the Kutz Indian tribe, and I have expertise in public health and sanitation, and I represent tribes on the State Board of Health.
Thank you, Steve. Welcome. Next, we'll go to Temple.
Hi, everybody. I think I'm unmuted. All right. I'm Temple Lentz, and I'm on the Clark County Council, and I also serve on our local Board of Health, and I'm here representing counties.
Hi, Temple. Welcome. Nice to meet you.
You too.
Okay, now we'll go to Tom, please.
Hi, everyone. I'm Tom Pendergrass. I'm a retired pediatrician and faculty member at the University of Washington and worked at Seattle Children's. I represent those with expertise in health and safety and sanitation.
Hi, Tom. Welcome.
It's much better to have you as chair, Keith. Thank you.
Glad to be back. All right, and yeah, again, I'm the last board member on record for today. My name is Keith Grellner. I'm the administrator for the Kutz Public Health District, and I too am on the board representing people experienced in matters of health and sanitation. All right, our first matter of business for today's special meeting is approval of the agenda.
Pendergrass, so moved.
Steve Kutz, second.
We have a motion and a second to approve today's agenda by Dr. Pendergrass and Steve Kutz. All those in favor of adopting the agenda, please say aye.
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 Opposed, please say nay. All right, agenda adopted. Thank you. Now we're going to move to agenda item number 2, which is an executive session. The board is going to meet in executive session for 15 minutes for the purpose of discussing with our Attorney General, Assistant Attorney General, who is legal counsel to the board, legal advice regarding potential litigation to which the board is likely to become a party relevant to the Spokane Regional Health District matter pursuant to RCW 42.30.1101I. The time is currently 3:37 p.m. We will resume this meeting at approximately 3:53 p.m. Okay, so board members, please follow the directions to attend the executive session. Members of the public, we will be back in 15 minutes. Thank you.
Before we get off, where do we find those instructions and to do that? Is it on the agenda or where is it?
Hi, Steve. You should have received an email from Melanie and Kelly.
Who would have it come from? I saw the stuff from Melanie to get onto this one, but
yeah, Steve, look at your email. Email from Melanie on May 27th at 2:52.
Okay.
All right. Thank you. We'll see you in executive session, and public will be back in about 15 minutes. Thank you.
Oops. Okay, I got one now.
Keith, are you ready for me to resume the meeting?
Yes, can you tell all the board members, all 6 of us have been able to join back on? Let's see.
This is Lilia. I think it's probably best to go ahead and get it started.
Okay. All right, go ahead, Kelly. Let's get rolling again.
The meeting is live.
All right, thank you. All right, welcome back to the State Board of Health special meeting for June 1st, 2021. The board is reconvening from executive session at approximately 3:55 p.m. on June 1st, 2021 on the GoToWebinar platform. All right, thank you. So next up, we are going to move to agenda item number 3, which is a preliminary investigation presentation from Ms. Karen Sutherland, our investigator. Ms. Sutherland.
Hello.
Hi there.
So what I'd like to do is go ahead and start by outlining briefly what I did. As you noted at the beginning of this meeting, the purpose of the preliminary investigation was to make a preliminary determination at the request of the Board of Health as to whether the Spokane Regional Health District Administrative Officer Amelia Clark refused or neglected to obey or enforce the provisions of RCW Chapter 70.05 RCW, particularly 70.05.050, with respect to the termination of SRHD Local Health Officer Dr. Bob Lutz. And the investigation was conducted pursuant to RCW 70.05.120. And to summarize, the allegations were that Dr. Lutz was removed from his position as SRHD Health Officer on October 29th, 2020, without notice and an opportunity for a hearing before the board as to the reason for his removal. And the report I prepared reflects the outcome of the preliminary investigation, which is one step in a larger process that includes me providing this presentation and then the Board of Health determining what they'd like to do as next steps. And so what I'm providing in my report is preliminary only. It's not a final determination as to whether Ms. Clark did or didn't refuse or neglect to obey or enforce the provisions of Chapter 70.05.RCW. In doing my investigation, I interviewed 7 witnesses. The determination as to who to interview was made by me, not by the Board of Health or by SRHD. And it was based on me reviewing relevant documents and video recordings of a press conference that was held on October 30th, 2020. And the SRHD Board of Health meeting information from November 5th and the information that I obtained through public record requests of the various entities that have members on the Board of Health. And I focused on witnesses with non-cumulative firsthand knowledge as opposed to interviewing everybody who might know something. And I also focused on folks who had knowledge of facts that were in dispute, not folks that, where everybody's in agreement on something happened. I didn't see a need to interview everybody about the fact that something happened, like the fact that a meeting occurred, for example. In making my findings, there are times when people had different perspectives on the events that we're talking about. And I made my findings based on a preponderance of evidence, which means that there is a more than 50% likelihood that an event did or didn't take place. And in doing that, I also weighed the credibility of witnesses. And in doing that, I used the same credibility factors that get used in a court proceeding. That is, they'll be given to a jury when a jury's making a decision. Not that that specifically applies here, but that none of the rules in doing this investigation specifically talk about how to make credibility findings. And so I figured that that was a good source to be using. for making my determinations. Also, keep in mind that if there isn't a preponderance of evidence, that doesn't prove that something didn't happen. It just means that the amount of evidence cumulatively is not more than 50% likely that it happened. So basically, it's an odds thing as opposed to a yes, this absolutely happened, or yes, this absolutely did not happen. So with that by way of background, my preliminary findings focused on going through chronologically the events as they occurred, and then taking that information and putting findings together. And initially, on whether there was any action taken to discharge or discipline Dr. Lutz during the executive session in the September 29, 2020 SRHD board meeting. And the reason that I looked at that was to determine what sort of guidance or expectations there may have been when Ms. Clark met with Dr. Lutz later that day. And so, as noted in my report, I looked at what happened on that day with respect to the information available about the meeting itself and the information that was made available afterwards by way of the press release from SRHD and the press conference as well. And also I looked at information that came out later, but I put a heavier weight on the information that was coming out shortly after the event happened, because that information is closer in time to the event happening. And also I think is more reflective of what people were thinking and doing at the time, as opposed to later after there were questions raised about whether the process had been appropriate or not. And people at that point would have more of a motive to, they'd be looking at things through the lens of, was this done right or not, as opposed to just, laying the facts out there. So after going through the information that was available to me about the board meeting, I did not find a preponderance of evidence that there had been action taken at the board meeting in executive session to remove Dr. Lutz. And again, that doesn't mean it didn't happen. It means that there isn't a preponderance of evidence in the information available to me that it happened. And in looking at that, one thing to be kept in mind is that I have very limited access to what happens in an executive session. Under the Open Public Meetings Act, executive session information is protected. And so in asking questions that raise issues that came out of the executive session or that talked about things that happened in the executive session, counsel for the SRHD board was instructing the witnesses not to answer. So the information that I have in my report is what I have. There would be additional information about what happened that would be more direct, but it's something that I don't have access to as part of my investigation. My next step was to take a look at whether Dr. Lutz was removed from the local health officer position by Ms. Clark on September 29th, 2020. That is basically what happened in the meeting that occurred shortly after the board meeting when Ms. Clark met with Dr. Lutz. And there are several parts of this meeting that are undisputed, and those I outlined, noting which parts are undisputed. And then after going through and analyzing the undisputed parts, I put in the information that was disputed and made findings as to what, based on a preponderance of evidence, I think the evidence shows. And in doing that, I found that there was a preponderance of evidence to support that Dr. Lutz was not given notice and an opportunity for a hearing before being removed on the 29th. In other words, I found that in that meeting, he was told that he was terminated effective immediately and was given a severance agreement that had a separate date.
Karen, just a point of clarification. We're talking October 29th.
October 29th. I apologize.
That's okay.
At any rate, on October 29th, that he was told that he was being terminated. And again, there's a dispute about that, but I'm basing my findings on a preponderance of the evidence. And he was given a separation agreement that stated that his date of separation was October 29th. And I, in making those findings, I focused on removal instead of using termination. You know, I talked about termination when I was making the findings and what Dr. Lutz was told, but later on in the report, you'll see me keep referring to removal. And that's because the statute that we're looking at talks about the removal of a public health officer as opposed to using the word termination. But the findings that I'm making, it would apply if the statute said termination instead of removal. The findings would still support by preponderance of evidence a finding that he was terminated effective October 29th, 2020. The other things that I took a look at that I think are important to note are that he was told that he was terminated effective immediately, but was given until 4 p.m. the next day to indicate whether he would like to resign, you know, basically to convert his termination to a resignation in lieu of termination. And he didn't do that. So if nothing else had happened, he would have been terminated effective October 29th, 2020. And then the next question that comes up is, well, what about being placed on paid administrative leave? Ms. Clark stated that she placed him on paid administrative leave on October 30th. The thing is, though, that there isn't any evidence other than her saying so to support that. Specifically, he was given until October 30th to convert his termination to resignation. When that didn't happen, you know, he was placed on administrative leave on November 2, retroactive to October 30th. And that's shown by the communications between Ms. Clark and Sue Winters, who is the HR person. And it's important to note that in doing that, initially on October 30th, Sue Winters reached out to Ms. Clark and, among other things, said in an email, I want to confirm that his last day of pay and employment was yesterday, meaning October 29th, and it is not eligible for rehire. And in her reply back to that, Ms. Clark didn't say, no, he's on paid administrative leave. Instead, there were several different questions in the email, and at the end of that question, which also had information about his benefits termination, she put okay. And that, along with the information that was being sent out to the employees within the health district about it being his last day, and the information given to him during the meeting, and the information provided at the press conference that was on October 30th, all supports that his last day, you know, was October 29th. He's being placed on paid administrative leave retroactive to October 30th, which happened on November 2nd. You know, so there's a break in between. You know, he's terminated for all practical purposes, and then on November 2nd, he gets placed on paid administrative leave. And so I talked a little bit about that in my report as well, as to what the impact of that was. And basically, the question that I was asked to look at was he removed from his position on October 29th? And he was. And he wasn't restored back to his position at any point after October 29th. And so because of that, you know, I found that he was removed from his position as of that date. Making it retroactive didn't somehow unfire him or unterminate him or unremove him. It basically meant that he got put back on paid status through November 5th. And at that point, additional steps were taken to terminate him. And the scope of this investigation was to investigate the complaints that were brought on November 3rd, which was before the meeting on November 5th. And so our report doesn't address whether the procedures that were used in the termination on November 5th were adequate or not. But what I'm looking at was he removed on October 29th? And he was. And so a question may come up as to, well, what about, you know, what if he had been put on administrative leave? Would that have counted as a removal? You know, what if it had been put on administrative leave, you know, on October 29th or October 30th? And the thing is that isn't what we have here in terms of facts. If, for example, there had been an interest in placing him on paid administrative leave so that an investigation could be conducted or something like that, that would be a totally different fact pattern than one we have, because the fact pattern we have shows no intent to conduct an investigation, no intent to restore him at some point to his duties, but simply to remove him and terminate him from his employment on October 29th, while giving him, the opportunity to change that to resignation if he did so by 4 p.m. on October 30th. Another issue that I think is important to address is the concept that Ms. Clark didn't have the authority to terminate him or remove him. So because of that, he couldn't have been removed on that date, and in fact didn't have action taken against him until November 5th. And the thing about that is that gets kind of tautological, because what this investigation is looking at is whether an action was taken to remove him that violated the law. And so, an argument that, well, this couldn't have happened because it would have been illegal to remove him is, a tautological issue, because that's what we're looking at is, was action taken that was illegal, there wasn't violation of the statute. And my findings were that there were. And again, this is preliminary findings, not final findings. The next thing that I was asked to do were to make recommendations, and the preliminary investigation recommendation is that there was that Ms. Clark did violate the statutes referred to in my report by removing him without providing him with the notice and hearing that's referenced in the statute. And then the next things that I looked at are the possible next steps. And what I put in my report is not every possible next step, but some steps that could be undertaken. The first one being that the board could request further information if it can't reach a conclusion based on the results of the preliminary investigation, or close the complaint if the Board of Health concludes that Ms. Clark did not fail to obey or enforce the provisions of RCW 70.05. And the next one is that if the board determines that the preliminary investigation so warrants, the board can call a hearing to determine whether Ms. Clark is guilty of the alleged acts. And that hearing would need to be conducted pursuant to the provisions of the Administrative Procedure Act, which is RCW Chapter 34.05. And if the Board of Health then does find that Ms. Clark refused or neglected to obey or enforce the provisions of the Chapter 70.05, the Board of Health may, but is not required to, remove Ms. Clark as the SRHD administrative officer, in which case, if they did determine to remove her, she couldn't be reappointed except with the State Board of Health's consent. Another thing that's outlined as a possibility is that the State Board of Health procedures state that the board can direct the officer to remedy the failure if it finds that the officer did not, or if the officer did refuse or neglect to obey or enforce the provisions of the Chapter 70.05. I noted in my report that Ms. Clark doesn't have the authority to reappoint Dr. Lutz without the approval of the SRHD board. And the point I was making there is this is a complaint against Ms. Clark, not against the SRHD board. And if the State Board of Health was to order her to reinstate him, she can't do that on her own because the SRHD board's process would require that it be the one making a determination. And again, that's it. He was, at least, according to the procedure that happened on November 5th, Dr. Lutz was removed, was terminated. Again, my preliminary findings are that he was actually removed from his position on October 29th. The board took further steps to have notice and a hearing on November 5th. And at that point, they voted to terminate his employment and also voted to put somebody else in that role. And so Ms. Clark by herself can't undo that. And so the point I was making in my report is that any direction from the State Board of Health to remedy the failure of her actions, that is, to remedy the removal of Dr. Lutz, if there was an interest in having him reinstated, she could certainly ask the SRHD board to do that, but she can't do that on her own. So that's pretty much an overview of what my report, my findings are. Does anybody have any questions for me?
Board members, questions or clarification from Ms. Sutherland?
I do. Zaskia Crocker. Can you hear me, Keith?
Okay, go ahead. I can't. Go ahead, Zaskia.
Oh. So my question is, the only remedy, if we decide that we believe that Ms. Clark needs to remedy this situation with Dr. Lutz, is the only remedy to reappoint him, which she doesn't have the authority to do that, I understand it would have to go to the board. Is that the only type of remedy we could make for Dr. Lutz? Because Dr. Lutz may not even want to go back to that role. What other type of remedies are there?
The options that I went through are from the procedure that is in the Washington State Board of Health Policy and Procedure, and it's examples.
Okay.
I laid them out because they're the examples that are listed in there. That doesn't preclude you from coming up with some other remedy other than the ones that are listed.
Okay, thank you.
Tom Pendergrass, a point of clarification. I believe that you said that you did not do any investigation of what the board, the Spokane Health Board did on November 5th. Did I hear correctly?
What I did was I went through and watched the hearing and read the minutes and basically took all of that information, because that information includes testimony and statements about what happened prior to that date. So what I was doing is using that information to help me understand what happened prior, what happened on October 29th and what happened with respect to placing him on administrative leave. But what I wasn't doing is deciding whether, for example, they followed the right procedure in terminating him. Did they give him a fair hearing? His lawyer made an argument that it should have been done under the Administrative Procedure Act. I didn't make a finding as to whether that would have applied to a Spokane Regional Health District hearing. So what I'm doing is simply saying, not that I didn't look at it at all, because I looked at it very closely, but for the purpose of seeing what evidence was there that helped me understand whether he was removed from his position on October 29th.
Thank you.
Yeah, Steve Kutz, a couple questions, I guess. The initial meeting, there was an executive session prior to the meeting where he was told he was terminated. When they went out of executive session, did they take any action?
On that, no.
Okay.
I don't remember if there were other agenda items after that they did act on at that board meeting, but no, they did not take any action related to Dr. Lutz, his employment or anything like that.
So I was trying to pay particular attention as you walk through things, and when you talked about the meeting, the health board meeting where they made the decision to terminate him, was there actually a hearing where issues were presented and rebuttal was made?
Yes, in the meeting on November 5th, they put out notice ahead of time of that meeting and held that meeting, and they did have executive sessions during that meeting, but they came out of executive session and voted to terminate him and appoint somebody to take over on an interim basis.
So I guess what I was trying to find out, whether it's belated or not, was he given his right? Was he given his right to a hearing under the regulations?
Well, he was given a hearing, he was given notice and a hearing on November 5th. And I didn't make a specific finding as to whether that hearing was done appropriately or not, because I was focusing on what the complaint was that I was retained to investigate. His lawyer raised an issue as to whether the hearing on November 5th should have been conducted under the Administrative Procedure Act instead of under the local rules, the health district's rules. And because I wasn't asked to make findings on that, I didn't. I certainly could if that was part of my scope, but I didn't see that as part of my scope based on the complaint as it was given to me initially, because it was focusing on what had happened when the complaint was made, and the complaint was made on November 3rd, which is before that November 5th meeting happened. And, if you're thinking about possible next steps, one thing that if that was something that your board wants to know more about, one of your options coming out of this meeting is to direct me to go back and provide, basically, make findings based on that as well.
Thank you.
Just for clarity, he was actually terminated on the 29th of October, and any hearing or questioning or opportunities that happened after, he was already terminated on the 29th, correct?
My findings are that there's a preponderance of evidence to support that she terminated him. The problem is that termination process did not match what the law requires. And so they then went and did another process.
So it's kind of like cleaning it up after the fact, but he was already terminated, which violated the law. Okay, I better stop there, right, Lilia? Okay.
I'm just going to jump in and I appreciate the discourse and the questions and the answer. Just to remind board members that the preliminary findings are just that, they're preliminary. So they don't prove anything at this point.
Okay. Basically like laying out facts and observations and things that you would then flesh out in a hearing that's held pursuant to the Administrative Procedure Act, where you would have the opportunity to have testimony from everybody and but testimony from folks with relevant perspectives to provide. And then you would be defining, it's not something that, this is all preliminary. This isn't, a final determination of any sorts.
Steve Kutz, I have a follow-on question.
Mm-hmm.
So I do understand going into an executive session and having attorney-client privilege. I really understand that from way more than just state board health meetings.
Mm-hmm.
However, when you ask some questions regarding decisions leading up to, I think it was October 29th, you hit a stone wall of executive session. Is that correct?
Yes.
Okay. Thank you.
Yeah. I did not, they raised that. I accept that that's what they raised. I did not, there isn't somebody for me to take my determination to rule on whether that's accurate or not. And as one of the witnesses, noted, he wanted to be on the record that just because something says it's attorney-client privilege doesn't necessarily mean it is. But I don't have a way to compel somebody who's asserting that to respond or to, really analyze whether or not the privilege applies or the Open Public Meetings Act applies to a specific thing. There is an AG's opinion out there about how any duty of confidentiality cannot logically extend beyond the purpose of a properly convened executive session. And a member of a governing board who discloses only discussions that improperly took place during an executive session hasn't violated the duty to honor the confidentiality of proper executive sessions. And that's an Attorney General's opinion from 2017 called AGO 2017 number 5. But when faced with somebody putting up a wall saying we're not going to respond, I don't have subpoena power or somebody, some way to make them respond. I accept that that's what they're being directed to do, and then make my findings based on the other information available to me.
So I guess as a final question, as a follow on to that, you asked some questions about some facts, and you and did not get some answers because you said you heard executive session was in action. Is that correct?
I would ask a question such as, this is paraphrasing because I don't have my interview notes in front of me, but something along the lines of, when you left the executive session, what was your intended meeting with Dr. Lutz? And I get the, objection, you can't answer that because that would be disclosing what happened at the executive session.
Okay. So I understand then. Thanks.
Yeah.
Hi, Temple Lentz. I think that you've just answered my question, but I'm going to ask it a little differently just in case. So if we were to say specifically around this extended executive session that they had, if that we had additional questions about it and say we wanted more information, is there any opportunity or recourse to ask for a waiver of confidentiality or to get a ruling in some way on materials or information that the claim of attorney-client privilege is being made, but it might not apply?
You're probably better off asking your AG about that. I mean, from a practical perspective as an investigator, I can say there's nothing preventing me from sitting down with their lawyer and saying, look, you've read the report, you've seen how this went. Can we put some guideposts up here that would allow me to obtain additional information from your witnesses and see what happens? But that's not the same as, is there a legal basis for which, somebody could go into court and get them compelled to answer? And for that, I would say that asking your AG, your assistant AG for an opinion on that would probably be a better way to go.
I think that would be somewhat difficult. I mean, there's certainly that her attorneys are, or the county's attorneys are correct. There are laws that support the fact that executive sessions are confidential. So if that is something the board is interested in, we'd have to take a closer look.
Yeah, and there's also penalties for individuals who violate the Open Public Meetings Act by sharing things that happen in executive session as well.
Right, board members. Other questions for Ms. Sutherland? All right, seeing none. Karen, if you can maybe stick around for a little bit here.
Sure.
I appreciate that. Thank you for your report. Very thorough. All right, board members. Discussion of next steps. Dr. Pendergrass.
Here too. Now can you hear me?
We can. Thank you.
There remain a number of questions about what happened in the board meeting before the meeting with Dr. Lutz and the executive director in the evening. And there are still questions in my mind about if there was a movement to move toward termination, why was that not made by the board at that time so that she could execute that in the other? And I hear very clearly that we sent Ms. Sutherland as an investigator. We didn't send her with subpoena power. We didn't send her with judicial imprimatur. Therefore, I think we're in that setting. So I'm going to see if I can guide the discussion and at least open it up and move that the board determines the information provided is insufficient to reach a conclusion as to whether a hearing is warranted, and request that further information be obtained in a hearing before the board, including Ms. Clark.
Thank you, Dr. Pendergrass. We have a motion on the floor. Other board members, do we have a second?
Wait, Fran has something to say.
I have a question too.
Okay, we should.
Fran, we can't hear you.
Can you hear me now?
Yes.
We can.
Tom, I'm confused by your comment. Are you saying that you are making a motion to possibly have a hearing?
I can reread this if that would be a better use of the time. I'm going to choose the third option in our guidelines. The board determines that the information provided in the preliminary hearing warrants a hearing to determine whether Ms. Clark is guilty of failing to obey and enforce provisions of RCW 70.05.050, and directs the staff to notify Ms. Clark that a hearing will be scheduled and notice provided pursuant to the provisions of Chapter 34.05. I guess that's my motion now. I am
in that case, I would second
it. What I'm saying to you, Fran.
Yep, I do. I'll second it. I'll second.
Okay, we have a motion and a second. Now we can get into further discussion. And I see we have 3 people up. Let's go Steve, Vazoskia, and then Temple. Oh, Steve left. There he is. Steve, you're still on mute.
Yeah, I guess, Tom, my issue, I guess, in asking for a hearing and only mentioning the one individual limits our ability maybe to get to the bottom of what occurred. That's my only concern about holding a hearing under those circumstances. Thanks.
And so I'm on the same lines again with it. My question is that even if we did hold a hearing, would we have subpoena power for them to even talk about what went on in the executive session? Because if we can't get them to answer those questions as to what happened, then having a hearing won't help us any more than what we already have. So unless we're going to be able to get them to share what went on, I don't know why we'd have another hearing or have a hearing.
Okay. Temple?
Trying. My unmute button disappeared on me. I feel similarly about the unlikelihood that we would get additional information. I was initially leaning toward the notion of seeking additional information, since there is this huge gap in our information. But I think that if the Board of Health is not, if the local board is not willing to waive confidentiality, that is an option that they would have, and then they would not be violating the provisions of the RCW if they chose to waive the then we could potentially get more information. But if they're not willing to do that, then we're working with what we have and could potentially go a little bit deeper, perhaps in a hearing here from Ms. Clark, since she's not with us today, and get a little further. But if they don't waive the confidentiality, then we have to work with what we have. And if no other information from the board is being provided, then working with what we have, we can try to make a determination. So I would be supportive of moving in the direction of this motion.
Fran, did you want to comment? And Steve, then I'll go back to you.
This is Fran. Can you hear me?
Yep.
Now we can.
Okay. The complaint was against the administrator, not the board. So I think we have to be cautious on what we're asking for here. And, you know, I don't know that we can go any further to request any more information from the board, because the complaint that we did receive was strictly about whether due process by the administrator was correct.
Steve and then Tom.
Yeah, I guess so getting into all of the comings and going and an executive session, I don't think is really necessary. What is necessary is to understand the authorizations that Ms. Clark had when she had her conversation with him, where she told him he was terminated. That is, I think, what is the crux of what I want to understand. Thanks.
So if I could respond to some of the concerns that have been expressed, I'm going to say to you that whatever they did in executive session, if they were moving toward a termination, they should have come back to open session, had that discussion, and made a motion to say we are moving toward a hearing and termination. At no point has that been a contested issue, as I read the documents we have in front of us. So we're left with, well, what led Ms. Clark to decide that she had been told that it was okay to dismiss this physician, and why is it that she chose to do it the way she did? We have hearsay from Mrs. Clark, from the person who was in the room, from the board, and from Dr. Lutz. But that is hearsay. It is not under oath testimony. This is what I did and heard. And that's the reason I'm saying it sounds to me like we've got to go to a hearing, a formal hearing under the RCWs, to make sure that we understand whether or not the rules as prescribed in the revised Code of Washington were followed. I don't see how we get to that point without going through a formal legal hearing.
Yeah, oh, go ahead, Mazafia.
That's not what it is.
Okay. Yeah, I'm really torn on this one. Having read the preliminary report multiple times now, you know, it's at least based on what we have in front of us, it's really clear to me, at least in my head, that there was clearly intent to terminate Dr. Lutz. The interviews with the newspapers, the press release issued by the district, and if Ms. Clark is the agency lead, which we've been told that she is, you know, that press release was released under her authority. You know, we heard how during the Board of Health hearing on November 5th, you know, we heard from her taking Dr. Lutz to task for sending a letter where he didn't follow the proper procedures and she okayed it. So I'm only left to believe that if that press release that went out on the 30th, which said that he was no longer the health officer, that she had to approve that and must have approved that. And based on, again, the other interviews, the hearsay that Dr. Pendergrass just mentioned, I mean, in my mind, it appears clear based on what we have at this point, preliminary information, that there certainly was intent. The other questions I have, again, or questions I have still in my mind that a hearing could help with. I would like to see if we could tease out legally the term removal. You know, he got paid for all that time between the 29th and November 5th. So he was paid. He didn't have access to any of his materials. So I'm not sure, under a legal standing, the intent seems there, but was he actually removed, or was the process of removal started? And then on top of that, I guess ultimately, what's also clear to me, at least from the preliminary investigation, is that whether the board directed Ms. Clark or did not direct Ms. Clark earlier than the 5th to terminate him, they certainly, at least as a full board, the way they voted, they certainly, if errors were made, and human resources can be very challenging, but if errors were made, the board certainly announced their intent to back Ms. Clark, that they held the hearing. They had 30 minutes of testimony from Ms. Clark, 30 minutes of testimony from Dr. Lutz, and then they made their decision. So part of my head is going to the part that, yes, if errors were made, did the board try to correct them and bail Ms. Clark out? And I believe that they probably did. But again, the answers to some of these questions, the only way to get at them at this point is to have a hearing and have at least Ms. Clark testify under oath. And, as far as the rest of the board, we can ask, and they could testify if they wanted to, or they could choose not to and let the record stand as it may. And then, again, it's left at the decision of the State Board of Health to determine whether the violation occurred or not. And so simply as a matter of trying to find the truth in all this, and it's a little muddy, I'm also leaning towards having a hearing, although I'm not quite sure, based on the board's actions to rectify any potential errors, I'm not sure what the hearing will solve other than finding out more of the truth. Lazowskia.
This is my last one. You know what? And I just have to truly just speak my truth here, is that I think we had ample information that was provided that Ms. Clark was wrong. She did not follow the RCW, her role and responsibilities. That is her job as administrator. She should have known. And there's no denying that he was terminated on the 29th. Regardless of recovery, it was wrong. And so for me, it's a question of how do you remedy this? And that remedy, I don't necessarily think it's reappointing him to a position that he may not even want after the treatment, the lack of protocol, the denial of what's happened, and the board support, whether it's blindly supporting their administrator or not, they should have known as well to follow the protocols of the RCW. So the board, which we can't hold responsible because it's not them, it's the administrator. But the reality of it is that they didn't follow the law. And I think we can have more and more hearings, but at the end of the day, we have so many meetings. We know what happened. He was terminated and they didn't follow protocol. So that's where I stand on it. I don't need another hearing to hear what was clearly outlined in the investigation that they violated the law. That's all I have.
My rebuttal, Vazaskia, would be at this point, we are still dealing with interpretation, information sharing. We have not done a legal procedure. If we're talking about any penalty for Ms. Clark, we need to now follow the rules that we say they did not. And so I'm saying we've now got to follow the rules for how we evaluate her performance, you know, and following the rules so that whatever decision is made about her is there. I don't think we're talking about Dr. Lutz in any way. We're talking about the administrator and how she executed a personnel matter.
Thank you, Dr. Pendergrass. You cleared that up.
This is Fran. I totally agree with you, Tom. And I do have some other questions, but it would be the hearing that would clarify them probably. And Keith, your questions were so valid too, and I agree with that. So I think the only proper thing to do is to have a hearing. And if we don't, I think it's also not fair to Ms. Clark.
Karen, can you pop on again for a moment, please?
Yes.
Thank you, appreciate it. So I think you told me this, and I was trying to scan your report really quick again, and I didn't pick it up. So I'm just gonna go right to you to answer it directly. When you interviewed all the people, they were not under oath, correct? During the interview, it was a voluntary interview.
Voluntary interview, and I ask each of them, will you answer my questions truthfully and completely? Not surprisingly, they all say yes. I've never had a witness say no, but it's not sworn. You know,
Thank you. Yeah, I think that's the other part of this that that a hearing would help us tease out, because Ms. Clark, Dr. Lutz, and anybody else who we can get to testify or compelled to testify, they'll be under oath. And I think that could help us clear up a couple of these questions, because this is not a simple, straightforward case in my mind. There's a lot of intricacies involved. And I think, especially Ms. Clark, having her testify under oath is really the only way for the board to hear those answers directly from her. And since the complaints are against her, and I think it's only fair that we give her the opportunity to answer some of our questions before we try and make a decision on a violation of the law. Board members, any further discussion or questions of Ms. Sutherland? Okay, hearing none. We have a motion and a second that simply stated, the board determines that the information provided in the preliminary investigation warrants a hearing to determine whether Ms. Clark is guilty of failing to obey or enforce the provisions of RCW 70.05.050. The board directs staff to notify Ms. Clark that a hearing will be scheduled and notice provided pursuant to the provisions of 34.05 RCW. So with that, if there are no further questions or comments, we will call the question. All those in favor of the motion on the table at this time, please state aye.
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 Opposed, please state nay. Abstentions, please state your name. All right, thank you, board members. That motion was passed unanimously. So we will direct staff to notify Ms. Clark, and we will set up a hearing to pursue this matter further. Thank you, Ms. Sutherland, and thank you, board members. So next, we are moving to agenda item
5.
Michelle, was there anything with agenda item 4 that we needed to finish up for board staff before we move to 5?
I believe that staff have captured the board's action from today, so I think we're okay there. Thank you.
Right, thank you. Okay, so we are at number 5, which is review and discussion of board policy 2015-001. Lilia, you're up again.
Okay, thanks, Keith.
Thank you, Lilia.
So since you have decided to go ahead and call a hearing, then the next question is who should be the presiding officer for the hearing? This does not mean who is the decision maker. The board remains the decision maker, but it does mean who will take care of the procedural aspects of a hearing. And depending on who is chosen, then that person and that person's staff will go ahead and start applying the APA to process and procedure, including contacting Ms. Clark, issuing a notice of hearing, and that sort of thing. So you have some options as are set forth in the memo that was posted under this agenda item. And the options really come down to the board itself as a quorum can serve as the presiding officer. Fewer than that number can also serve as the presiding officer. There is also the opportunity to hire an administrative law judge from the Office of Administrative Hearings, and that person is familiar with acting as a presiding officer. That's what they do. They do it for other boards and commissions, and they can help with all of the procedural matters. They can, whatever happens, it's the board's decision. So the board issues the final order. There is an option on here for an administrative law judge to issue an initial order, but ultimately it comes back to the board to issue a final order. So those are the options. Again, there are boards and commissions that do take advantage of hiring an administrative law judge who is familiar with how to conduct a hearing and take care of process and procedure for you. It doesn't mean that you won't be involved in making a final substantive decision. It just helps to ensure that all of the procedural requirements of the APA are met. So that's kind of the long and the short of it. Are there questions that you might have I can answer?
Let's go to Steve and then Tom.
Well, I don't really have a question other than I guess I kind of have a recommendation because if we have you, Keith, as our chair, preside over that, that stifles your participation, which I think would be really important in this in this issue that's really going on from a public health point of view. Thanks.
Yeah, Tom.
I support the request for an administrative law judge because I think we're moving out of the usual realm of expertise of the board, and this has potential ramifications for Ms. Clark. So I believe we need that legal guidance and being kept on the straight and narrow. And in no way am I impugning Lilia and being able to do that. She keeps me in control all the time.
Thank you, Tom. Yeah, well, it wouldn't be me. But so again, process and procedure, you guys are still responsible for substantive final decision.
Understood. We're still the decision maker. We're the jury, but I think we need another arbiter at the head of that event. Thank you.
And I just want to support that because I just listening to Lilia, I immediately thought that we did need an administrative law judge and I support that. So whoever makes the motion, I'll second.
My concern is the budget. Michelle, who pays for this and how do we work it through? Okay, still take care of this.
So when we first received the complaint, and we realized the importance of hiring a third party, I engaged in conversations with the Department of Health on this work. And so the Department of Health has provided some financial assistance. This is not an action that's typical to the board's budget. There is statutory authority for the department to provide support to the board to carry out its work, and that's how this whole process has worked. And so I would continue having conversations with the Department of Health, and they have not at this point indicated that it would be problematic for us to move ahead with an administrative law judge. And I can get back to you if you want a deeper dive on the specifics of cost.
No, I was just concerned, but not that I don't agree we should go ahead with this, but just
right. I
have a
appreciate
question
that.
as to process. Yeah.
Thank you.
Mm-hmm.
Lilia, could you tease out for us a little bit in our board packet on tab 5A, we have those 4 options. And the last 2, I think it sounds like the board's leaning towards one of the last 2. And it's where we either hire, in both of them, we hired an administrative law judge. One, that law judge could also be responsible for issuing the initial order. And the second one is we had hired the administrative law judge, but they would not be responsible for issuing the initial order. Could you kind of tease those 2 out for us a little bit, so when a motion is made, everybody's going into this with open eyes, please?
Yeah, so there, I believe there is an administrative law judge cannot issue the final order. That if they issued an order, it would be an initial order. My understanding is that most boards and commissions that take advantage of this approach just issue their own final order rather than having kind of that interim order that isn't ultimately going to be the final order anyway. So the more we looked at this, the more that looked like it wasn't necessarily more efficient to do it that way.
I would also say it's weaseling on our responsibilities as the State Board of Health.
Yeah, I agree with you, Steve. And then when we're questioning, when we hold the hearing, does the administrative law judge do the questioning, or Lilia, will you be helping us or the board to do the questioning?
So I will be helping the board come up with, well, I will be helping the board we will have another attorney from our office who will present the case, ask the questions of the witnesses. And then as the decision makers, there will also be an opportunity for board members to ask questions if, like a judge would, if something is left out from the questioning that has already occurred and a member feels that they want to ask a question.
Okay, thank you. All right, board members, any further questions, or do we have a motion? You all went on at the same time. So whoever wants to go first, go ahead and raise your hand and go ahead and start. Okay, Temple.
Okay, I move to direct staff to hire an administrative law judge through the Office of Administrative Hearings to serve as the presiding officer for the purpose of conducting the hearing, but not for issuing an initial order.
I second. Bozovsky.
Okay, we have a motion and a second. Further discussion or comments?
Yeah, I would just like to say change it from preliminary order to final order on the motion. There may be a distinction between the two. I'm not sure. It just if you word it that way, it seems like there's more to happen.
Lilia, could you help us with that question between initial and or final order?
So what I heard, Steve, what I heard was a motion that to hire an ALJ to serve as the presiding officer, but not to issue an initial order, which means that the board will just issue the first and only final order in the matter. Does that help?
Perfect.
Yes, it does. Thank you, Lilia. Further questions or discussion?
Yeah, I guess I have some follow-on questions after we vote on this, I guess. So thanks.
Okay.
Call for the question.
We'll go ahead and call the question. All those in favor of the board directing staff to hire an administrative law judge through the Office of Administrative Hearings to serve as the presiding officer for the purpose of conducting the hearing, but not for issuing an initial order, please say aye.
Aye. Aye.
Those opposing the motion, please say nay. Abstaining, please state your name. Okay, motion passes unanimously. Steve.
Yes, I was wondering if we were going to have some kind of a meeting, whether it's I presume it would be an executive session, where we at least formulate some questions, or we to be presented by the questions that we might think about from the person that was from the AG's office that would come in and act as, for lack of a better term, like the prosecutor or something like that. I just know that we all have questions, and some of them maybe fall around some of the same themes, but or I don't know, just a question. Lilia.
Go ahead, Lily.
Yeah, well, we can talk about that further. I think that questions that the board has can be formulated once you see whether or not your questions might be covered by the person who is helping to put on the case. But yeah, we can talk. We can figure out if there's a way to follow up with areas of questioning that you're particularly interested in. And once we move into the APA arena, then well, we would need to figure out how to do that procedurally, but I'm happy to talk about that some more.
Lilia, before you go away, give me an idea of timeline. You know, we all love having Board of Health meetings, but I just want to know when to start worrying about my calendar.
Okay, well, here's what I can tell you. I don't know that I can give you a definite time frame, but now that the board has decided to hire an ALJ, then the next step would be to contact the Office of Administrative Hearings, get that going. Then staff at the Office of Administrative Hearings will help to start the hearing process. And I would think that a part of that would be to have what is normally referred to as a pre-hearing conference to get a good date scheduled for the parties. And so that would include Ms. Clark. And at that point, after that happens, then a notice of hearing would be issued with that date on it, of course. And I don't know, I would hope that all of that could take place maybe within the next month at the most. And then it would depend on the ALJ's calendar and our attorney's calendar and Ms. Clark's calendar. OAH can sometimes do it fairly fast. So I'm sorry, I can't quite answer your question, but I would sort of hope in the next maybe 3 months, something like that, we could get it scheduled, but we'll have to see what the parties' calendars look like and the judge.
My concern is that if we wait until, or we're delayed until October, that will have put her in limbo for a year, and that's not really good due process.
Well, again, the OAH can usually, in my experience, I don't know, I can't, I don't know for sure, but in my experience, they can usually move fairly fast. And so
I'm not asking you to make a command. I'm just asking, pointing out that, an expedient development would be desirable.
Okay, and if Ms. Clark agrees with that, then we can probably get it scheduled, hopefully in the next few months, I would think.
And then, Lilia, one other question. Are we allowed to seek or compel other testimony other than Ms. Clark's, or are we relegated to only Ms. Clark?
Oh, no, you can seek testimony of others that have information that's relevant to whether or not Ms. Clark, refused or neglected to obey the statute in question. So, yes.
Okay.
Just a quick question, I guess, Keith. I guess from my perspective, the reason we're going down this road a little bit is Ms. Clark did not acknowledge that she did not follow the RCW. If she had, we wouldn't be having this conversation. Is that correct?
What? That might be a question better for Ms. Sutherland, but reading the preliminary investigation report, I didn't see any quotes from Ms. Clark acknowledging that she violated the law. So I don't think we have that at this point.
Right. Thanks.
Lilia?
That's fine. I don't think we have that at this point, so we'll leave it at that.
Okay.
I'm not sure that whether that would make a difference would be up to the board.
Okay. Board members, other questions or comments for Lilia or Michelle?
I just want to thank Lilia for the work that she did.
Yeah, thank you.
You're welcome.
Yeah, Lilia and Michelle, they did a lot of work to get us ready for this meeting, and we really appreciate it. Tom?
I think we are blessed with great staff, and I thank them for helping us to move through this difficult situation.
Yes, very difficult. Okay, so next, board members, we'll move to agenda item number 6. Any last board member comments before we adjourn? If you would like to make a comment, just go ahead and turn on your camera, please.
The last board meeting just did not go as well as it would normally have gone with the chairman present. So I'm not sure that we're going to allow him to do that ever to me again. I mean, ever to the board again.
Over and out. Thank you, Tom. All right, well, seeing none, I'll just state what's already been stated. This is a super challenging, somewhat troubling situation that, we've been asked to intervene in through formal complaints, and we're doing the best that we can. We know that Ms. Sutherland did a really difficult but good job on her preliminary investigation, and we still have questions that we need to answer. Hence, we're going to the hearing. And board members, if you could start thinking about questions or people that you would like to hear from during the hearing, and maybe just start jotting some notes down. And then once staff connects with the Office of Administrative Hearings and we get that process started, then as Michelle and Lilia said, they'll circle back with us and we'll figure out a way where we can all share our thoughts with them to get ready for a hearing date. All right, with that.
Again, sorry, Keith, can I just again, you will have the opportunity at the hearing to ask questions for sure. So keep that in mind. Thank you.
Thank you. Okay, with that, board members, I'd entertain a motion to adjourn.
Oh, you were asking for comments, so I guess there could be something else that comes out of this, Keith. Because as a previous health administrator myself, going down the path facing this type of an issue, I think Wasalfo doesn't adequately prepare their administrators for difficult times. And so I don't believe that if I would have gone to my personnel office, I would have been headed down the right path over this kind of a difficult thing. So there's an opportunity here to do some learning as a state, I think, and as health departments on maybe better preparing people for some of the hard things that happen.
Yeah, that's well said, Stephen. I think organizations carry some of that responsibility. Not to mention the administrators themselves. I mean, the law is available to everybody to read. We usually have HR, human resources programs, and legal counsel. So, I mean, you're certainly right. I mean, these are very difficult situations, especially when you have, an elected board involved and two positions that are either at will or borderline at will that answer to the